My lord, item 9 and 10, the petitioner of this case, two cases, same person, against the same person, there are two cases. In one case, he has been declared as foreigner. Again, he started and he has been also declared in that case as foreigner. This person has died. So I have sent my junior to bring the copy. They have sent our mobile. So it is coming within 5 minutes. 9 and 10. Wahid answer. Originally, he is from Bihar. My lord?
After 2 weeks, both sides are represented on the prayer made by the counsel for the petitioner. The matter stands adjourned today, list after 2 weeks. Item 9 and 10.
For motion, item 1.
But in item 1, but I need 1 week time for in the affidavit in the matter. The pen drive we have placed, I have to bring the affidavit on record.
May I please, my lordship? My senior is in Kohima, sir. So can we be adjourned in case for?
No, he's taking an adjournment. Your prayer is not required. Both sides are represented. The Mr. T. Nath, Leonard Senior Government Advocate, pays for some time to file an affidavit. Prayer is allowed. How much time?
I need 1 week time.
Okay.
Let it come next week.
Let the affidavit be filed within a week or within a week. List on 28/7/2025.
For admission, item 2.
Lord, it has called for the case there.
Yes, my lord.
It has come.
Have you gone through it, both of you?
But today in the morning I could learn that it has come.
Okay, because
I have not seen, my lord.
the recent developments which are taking place, I did not have time to read it.
I'll check up. Give me some time.
Okay.
But it may take up on another day. In the meantime, I'll see.
You also can go through it.
Yes,
It will save us a lot of time.
yes, my lord.
Both sides are represented. The scanned copy of the case diary of GR case number 2362 of 2012 corresponding to Katigura PS case number 291 of 2012 has been received. Mr. P.K. Dekar, and counsel for the petitioner, as well as Mr. D. Nath, and senior government advocate, pays for some time to go through the case diary and to address the court. Matter stands adjourned today. List on when?
Next week, any date, my lord.
So let it be on 29th.
Okay, 29/7/2025. You go through it, just tell the portmaster, he'll give it
Yes,
to
my
you.
lord. Deeply obliged.
First, item 3.
But in item number 2, if not possible to see the case diary here today itself, can I go to the section and see, madam?
Just say the AOJ. Which section? Civil pending section shall permit the learned counsel for both sides to peruse the scanned copy of the case diary. Yes.
Item
Please,
3.
Lordship. My lordship, kindly see the affidavit filed by respondent number 7. In that affidavit, the respondent has admitted that the deceased was in custody, in the police custody.
No, that's not never disputed.
Yes. So for that, now, as there is no dispute on his custody, then for a fair investigation, I urge for a CBI inquiry.
Well, it's a. But there is a recent development here, Lord. I'm just placing the order dated 10/7/25. Against after the reinvestigation, again the FIR has been filed. And to that, my lord, they have filed a Narazi petition and order was passed on 10/7/25.
There is
They-
not the final order.
No, this is not I'm not saying that it is final order.
Please don't address the other side, address the court. And when the other side is on decks, please don't, and you button up your court. When the other side is making submissions, please don't disturb. Yes.
On 10/7/25, my lord, the order was passed. Lordship, may kindly come to the last page, my lord, page number 6. This is the
Just a
narrative.
moment.
This is the
Just a
narrative.
moment.
Lordship.
We'll read that order.
Malala, that the informant complainant, Mrs. Rimli Gogoi Shoikia is present and she has filed a protest petition, white petition number 209 of 2025, whereby she has submitted written objection in respect of the investigation conducted by the investigating officer in connection with Titapur PS case number 132 of 23, as not having examined sufficient witnesses during investigation and submitted final report without any proper basis, and thus has prayed to treat this protest petition as a complaint petition and also prayed to take cognizance of the accused persons in the instant case. The complainant informant in her petition alleged that the accused person in FIR, Mr. So-and-so, the then SP Jorhat, so-and-so SDPO, Titapur, and so-and-so officer in charge, Titapur PS, on 22/12/23 at about 3:30 PM, police personnel from Titapur PS forcefully picked up the brother of her brother, late so-and-so, without any reason while he was on his way to a nearby store to buy some grocery for some and dropped him back at home at 2:30 AM. On 23/12/23, her brother narrated to her parents that he was picked up by Titapur police and was taken to Jorhat Sadar police station, where Mr. So-and-so, the then SP, pointed a service revolver on his head and pressured him to confess to and take responsibility for the bomb blast which occurred at Lichubari, Jorhat on 14/12/2023. It is submitted that her brother was beaten by other police personnel. The complainant submits that her brother stated before the police personnel that he had no knowledge about the blast and pleaded innocence, but Mr. So-and-so threatened to kill him in an encounter if he refused to confess about his involvement in the blast. On reaching home of her late brother narrated before his parents and was seen crying, holding medical prescription and an ointment given by police. On 23rd, 24th, and 25th December, her brother was again picked up from their home in the morning and dropped back at midnight, and sometimes even in the next morning. He was always given an ointment along with the medical prescription when he was dropped at home. It is submitted that every day her brother narrated to his parents about the physical torture meted upon him. The torture inflicted upon him were severe, and her brother told that he doesn't want to live anymore and his dream of joining police force shattered. On 25/12/23 at about 9 AM, police personnel again picked up her brother from their home, and he was dropped back in the early hours of 26/12/2023. On that day, her parents found him very weak in comparison in other days, and he carried with him an ointment provided by police and entered home, dragging his feet and putting his head over the lap of his mother, and started to cry, saying that police have beaten him badly and he was unable to tolerate tortures meted upon him. And Mohanlal Meena put a pistol on his head and said that if he does not take responsibility for the bomb blast, he will shot dead by the next day. The informant complainant submits that her parents told her brother that nothing will happen as he did no wrong. Thereafter, her mother tried to feed him food by her own hand, but he could not eat properly as he was very weak. And while crying, he said that he was not involved in any illegal activity and his dream of joining the police and other services are being shattered as he will be killed by so and so. Thereafter, the mother of the complainant made him sleep. On 26/12/23 at morning, her brother was not found in his room and her parents started searching for him. When he was not found at home, they intimated the matter to Madhapur PS. Madhupur PS threw a missing complaint after coming back from and Madhupur PS while searching here and there. Her father found him hanging to a tree in the backside garden of their house. At around 7 a.m., police were informed about the hanging. After 5 hours, SDPO Titabar along with the police personnel came and without meeting any family members went to the place of occurrence of the incident. After some time, magistrate arrived and the body was taken down from the tree. But the police did not allow anybody to see the dead body of her brother. Complainant forcefully went to see the dead body of her brother and found that there were several injury marks on the leg, back, and stomach. It is further submitted by the complainant that on 19/9/2024, the investigating officer submitted a closure report under section 173 CRPC by final report number 12 of 24. Citing mistake of fact and White order dated 3/12/2024, an order was passed by this court for reinvestigation of the case by senior rank police officer who will be selected by the Superintendent of Police Jorhat. The complainant informant submits that the reinvestigation has been conducted in a shoddy manner and there are material deficiencies and some important pieces of evidence have been overlooked. The informant and witnesses also raised allegations against the other police officers, but they were not named in the FIR. The investigating officer did not interrogate the accused persons nor made any arrest. Further, the statements given by the informant complainant, her parents and other neighbors have not been taken into consideration by the investigating officer. The complainant informant further submits that the prime accused is the then SP and the investigating officer was also a SP in the instant case. It is further submitted that the investigating officer did not take postmortem into consideration, where it is clearly mentioned that there are bluish mark, black in color, present over the left buttock of size measuring 9 cm into 5 cm and bluish black in color present over the right buttock of size measuring 14 cm into 9 cm, which are antemortem and were caused by blunt force impact on the body of the deceased brother. The investigating officer also did not record the statement of the doctor who performed the postmortem as well as the statement of the doctor of Titabar Subdivisional Civil Hospital before whom her brother was taken for medical examination. Accordingly, the informant complainant has prayed to accept the Narazi protest petition and to take or cognizance against the accused persons. Had the informant complainant as well as the engaged counsel on perusal of the protest petition, I have found that the complainant informant has raised serious accusations against the accused persons. In order to proceed with the protest petition, the examination of the informant complainant and other witnesses are necessary. Hence, the informant complainant along with her witnesses is directed to remain present on the next day for recording of their initial statement, register a complaint a case forthwith, and a record of Titabar PS so-and-so tagged with the complaint case, and the court has fixed 11/8/25 for statement of the complainant and the other witnesses. So this is the recent development, Lord.
This postmortem, which is available here,
Yes, Lord.
is not in compliance with the notification issued by this court pursuant to the Supreme Court judgment that it should have the what you call the image of the body of how it is there. High Court has issued a notification for that.
In fact, I have noticed, Malab, page 99. They have indicated that
No, but it should, there's no mandatory requirement that the position of the body and all that has to be a part of the police report.
page 99 at below, Malab, they have indicated that this is the format of PM report is in compliance with the order dated 1/8/2018 passed by the Honorable High Court in WPC suo motu number 10 of 18. And note below 3 is also there, Malab. Videography and all these things they have done. Sunny, what is sure about that? What else?
The case diary available?
Case diary is right now I don't have one. Case diary is available. I have inquired. It is available at police station. But the investigation, second investigation was conducted by the SP Sivsagar. Because after the matter was recent, it was directed to be investigated by an independent IO. So he has investigated and submitted the report.
Where is that?
Well, page number 89. Well, this is the part of our affidavit in opposition.
I don't.
This is the relevant portion.
Just a moment.
Just
Please come again. I missed out.
well, page number 89 and 90 also. Well, page number 90 of the affidavit. It's a part of the affidavit in opposition. Paragraph number 12. Well, we have said that though the case has initially been endorsed to SIP Nirupama Das for investigation, however, on 6/1/2024, the case was re-endorsed to Inspector Miraj Dole, who after due investigation submitted FR of the case by FR number 12 of 24, dated 19/9/2024, again as per order received from the Honorable SDCM Titabar, and as per memo number so and so dated 8/12/2024, the
But
office
that
of
report itself is not there.
no, report itself is not there. My lord, I have indicated the order dated 10/7/2025. This was FR was been filed. The order today I have placed. Against the FR, again they have filed an Narazi petition that has been taken up.
No, but that won't do.
That
If there's a investigation, you see, we are in session of the matter,
my lord,
and we expect that everything which is there on record should be placed before the court. The
Well,
non-production of the report of the IO, the normal inference would be that you want to withhold it.
no, my lord, not at all, my lord.
Because every time we can't pass an order if for each and everything that you produce this, produce that.
Well,
It is the duty of the state to produce when somebody has died. We may, you see, we may miss something while passing an order.
My lord,
Does it mean that you will not produce it?
Lordship,
my lord,
the
the report of investigation of the SP and the relevant documents have been submitted to the SDGM court. My lord, I can produce that copy. My lord, you may give me 2 days time. I'll produce it. And the case diary I have inquired. My lord, it is with them. My lord, here is a case of suicide. My lord, the postmortem report.
No, it's a
final
case of
report-
suicide, but it's a it's very proximity to the arrest of the of the petitioner. Not, we can't say arrest. He was just picked up, and then proximity to his release is the suicide. We don't find any business of the police to pick up a person without giving an intimation that they are taking up this person to police station. Number one. Number two, you leave the person at 2:30 a.m. and then comes the suicide in the early morning.
Those are factual things. I'll make my submissions at time. The thing is that in connection with investigation of a case, there was a bomb blast. In connection
No,
with that,
you do whatever you
No,
want.
not-
Do it in a legal manner which is permissible.
definitely.
And then this case diary is not before us. We don't know how he has been picked up. We don't know whether he had been intimated to his family members of our picking up. This is something which is high-handedness
Look,
of the police. Why we should hear it? We should send it to the CBI.
case diary, I will produce.
No,
Within
no,
2 days, I'll produce.
you see that's you see that is something which is coming from you after we are expressing our mind. But what prevented the state from producing it? If there's nothing wrong, you submitted an FR. That means the final report that there is no offense made out.
Lordship.
And then you withhold the case diary.
But-
If you
Well,
withhold it, let the appropriate authorities who know how to investigate will do it.
In fact, my respectful submission is we are not withholding. We have submitted the report and the documents before the court below.
In that case, you'll have to, in
I'll-
that
I'll-
case, you'll have to produce the case.
I'll-
You'll have to produce the case diary. We are not required to pass an order. You look at the High Court rules in a habeas corpus matter or in a criminal writ petition. It must be disposed of at the earliest.
I have taken note of that. In fact, as there was no order, I have not called.
Because
I'll
no, it's
definitely-
okay.
on Monday, I'll
We that's why we are saying at the time of passing of the order, we may miss out something.
Malad,
But that doesn't mean that the state will not assist the court.
definitely, Malad, I take it, Malad.
Somebody died, postmortem report has to be there. We'll have to pass an order, then you produce the postmortem report, we pass an order, then you produce the case diary. We pass an order, then you give us something more. This is not how we expect the state to assist us.
Malad, I'll produce the case diary on Monday, Malad.
Lordship, the postmortem report says that he has a antemortem injury marks on his buttocks. But the further reinvestigation, which the state has submitted in the Titawar court, which I have learned, the report FR stated that while he was climbing the tree for committing the suicide, he got that black bruises in his buttocks. That was a joke actually, what they have submitted in the court.
Let us see, since we can't jump into conclusions. But it will be wonderful to see if he is right. It will be wonderful to see while climbing up on the tree, somebody gets injury in the buttock. It will be very.
Well, in absence of the material record.
Lordship, I have annexed a photograph of the tree as well.
Please don't interject when we are asking questions to. Please don't do it. This is something I highly dislike. This is not a TV debate going on. Every time somebody says that you have to retaliate.
Yeah, I mean, addressing the court.
No, do it when your time comes. Don't interject. For this third time we are telling you, don't interject. It leads to only adjournment of the matter. We will not take it up. We don't want the decorum of the court to be broken. We give you 2 days time to produce everything you have.
Lordship.
We are not limited to the order, but whatever is available
Lordship.
and relevant to the case.
Yes.
And also produce the case diary of that case where you have been picking him up on 6 or 7 occasions for that bomb blast.
Lordship.
All the connected things, because you are picking up in the bomb blast case.
Yes.
Then comes the suicide. For that, the second case is registered. So whatever case is registered against the petitioner, you produce
Lordship.
all the case diary and all
Yes.
relevant information.
Yes.
Not limited to strict reading of our order. The police will know what to produce.
Lordship.
Yes, you wanted to say something?
Lordship may kindly issue notice to the remaining respondents.
No,
Come
for
before
that,
the
we
judge.
don't need their presence.
Their statement is required because Lordship may kindly see the affidavit of R7.
You
When
see,
they-
this is, in this case, where you allege that the policeman is involved in the, let us say that we accept your term and say that they are involved in a murder. We issue them a notice. They come and say no. Please tell us how we will decide that.
he was a SP and he is serving in the police.
That's okay, but please tell us, we are asking you a question. Will it not be a disputed question of fact? That's number one. Number two, if in your Naraji petition, criminal case has been registered, a complaint case has been registered, do you think it would be appropriate for the High Court to step into it when the trial is already started?
Your Lordship, trial has not started. The order is not final.
This, for the first time, you are understanding something like that. What happens when a criminal case is registered? Or complaint case is registered and cognizance taken by the trial court? You expect to pass a final order on that day? Yeah, we have many things to learn. In fact, the bar, everybody will be enlightened. In registration of in a complaint case, how a final order can be passed will be enlightened.
The,
So please tell us, we are asking you a question. In a writ petition, you implead somebody as a respondent. He comes and says no. What do we do then? How will you decide a writ petition when disputed question of facts come?
only through an investigation.
Why we should give an investigation? There's a criminal case registered, complaint case registered on the basis of Naraji petition. So please let us do what we know.
Even in the second further investigation.
Please let us do.
I was
Please
the-
let us do what we know. Don't take us to a field where we don't know. I'm making this statement with some responsibility. Do you think the accused will come and say that, yes, I have done it? A policeman against whom you allege that they have not done things in a particular manner, do you expect that he will come and say that, yes, I have done it?
Your Lordship, when the state is defending them, then they should say something at least.
Not required.
The entire state is defending them.
Not required. We take cognizance of the facts which will be available in the case
Lordship,
diary.
can you see the affidavit of R7? When they have
We are
filed
not
the
inclined.
affidavit,
At this time, we are not inclined.
when they filed the affidavit, they stated the case is still going on. But before the submission of this affidavit, they have submitted the FR. That means they have done the perjury by lying on the affidavit.
Can't help it. If that's your thing, you please continue thinking that. You can't help it. Whatever we want to express, we will express it in the order. There's no point interacting. We are not here taking what you call discussing law. Whatever you want, you make your submissions, we'll pass an order. Anything more? You're Mr. A. Jawada. Your name?
Arif Jodhar. Arif Jodhar.
Mr. A. Jawada, Learned Counsel for the petitioner, as well as Mr. D. Nath, Learned Senior Government Advocate. From the materials available on record, it appears that the investigation of what is it case? FR number 12 was filed in which case?
Malak
What is the case
Titapur
number?
PS case 132 of 23.
Titapur case number, PS case number
132 oblique
132 of
23.
23. The investigation was handed over to Inspector Miraj Dole, DOLEY, who after investigation submitted FR number 12 oblique 2024 dated 19/9/2024 thereby giving an opinion to close the matter. Stop. On the basis of a protest petition filed by the family member of the deceased, it is the petitioner who filed it or somebody else?
Petition.
It is the petitioner, not high family, the petitioner, comma, filed order dated 10/7/2025, comma, passed by the learned subdivisional judicial magistrate within bracket M, bracket close Titapur. Direction was issued for registration of a complaint case forthwith, with further direction to tag the records of Titapur PS case number 132 of 2023. And the next date of the complaint case was fixed on 11/8/2025 for recording of the statement of the complainant and other witnesses. Next paragraph. Along with the affidavit filed by the concerned respondent, the postmortem report is with 7. The postmortem report is with affidavit of respondent number 7.
Lordship.
The affidavit filed by respondent number 7 on
25 June,
25,
me
25 June, 25/6.
25/6
page number 92.
92. Seven filed on 25/6/2025, comma, copy of the adversarial report together with a copy of postmortem report has been annexed. However, they said postmortem report does not contain the sketch of the position of injuries of the deceased person. Next paragraph. As in this writ petition, it is the case of the petitioner that pursuant to that unable to tolerate They're after coming back from the Madhopur police outpost, the deceased, namely, what is the name?
Dipankar Gogoi.
Dipankar Gogoi was found hanging from a branch of a tree in a tea garden behind their house.
Actually, not from Madhavpur police station. He was dropped from Titapur police station. on that day. Madhavpur is
I don't know.
outpost.
See page 11. See page 11 of your writ petition.
On the first day, he was taken.
We
to-
don't know, but that's what you say. Please read page 11 of your writ petition, paragraph E. After coming back from the Madhopur police outpost, while searching here and there, the father of the deceased found him hanging from a branch of a tree. Where is the statement that he was taken to Titapur? Okay, it is there at paragraph D. Okay. After coming from Titapur police station, the Titapur and Jorhat Sadar police station. He was found hanging from a branch of a tree in a tea garden behind their house. And it is projected that although the police was informed about the hanging at about 7 a.m., the police contingent came after about 5 hours. And thereafter, nobody was allowed to see the dead body. To stop. The petitioner projects that the deceased was taken into custody on several occasions. And he was subjected to torture and physical beating by the police. Next, by in light of such allegations, the Superintendent of Police, Jorhat, within bracket respond number 7, is directed to ensure that all relevant material, including the case diaries relevant to the case being Titapur PS case number 132 of 2023, what is the earlier case?
It is,
Bomb blast case,
yes, Lord. It is Jorhat PS case number 555 of 23,
2523.
paragraph 6 of our affidavit.
Okay. 23. Including all other material which are relevant to the inquiry about the circumstances on which under which the deceased, Dipankar Gogoi had been examined by the police, and his consequent and his subsequent death be produced. Next para, the said authority is also directed that the production of materials would not be limited to the requirements contained in this order. But he would exercise his own due diligence to produce all materials which are required for the court to appreciate to appreciate the matter, to examine the matter. Next paragraph. The learned senior government advocate is permitted to send a downloaded copy of this order to the said authority, who would ensure the production of all relevant materials before the court on the next date of listing. Mr. Nath, we are of the views that since the case of death, you will permit, in your office, you will permit the learned counsel for the petitioner to examine the materials available in the case diary so that he can also assist the court.
Lordship.
So please tell us the date when you will produce and when he can come and inspect.
But I'll instruct them to give me, hand over the documents by Monday, my lord.
So the counsel for the petitioner, when will come? Not the Bomblast case. Case diary relevant to the
132.
132.
Titapur 132.
Titapur 132.
Lordship.
Bomblast case, he will not be
Your
privy
Lordship,
to.
in that
Yes.
case, in the charge sheet has been filed in the bomb blast case. His name is not there. He is all cleared in that case.
That's okay, but we can't allow you to inspect that record.
Lordship.
We are making it clear.
My lord.
Because he would not be otherwise privy to the materials available in the case diary, but once you have given an FR,
Lordship.
he has a right to know about it.
Lordship.
So tell us when he can, he or anybody else can come and inspect.
My lord, if I get the record by Monday, he can on Wednesday see me. On
Wednesday.
On Wednesday he can see.
Yes,
Lord, if Lordship has finished the dictation, my lord, just in the preceding paragraph, Lordship has said that the Miraz Dole inspector has submitted the FIR on 19/9. That was and then SDGM has passed an order for reinvestigation. Reinvestigation was given to SP Sibsagar. He again filed the FR. Against this, the order has passed. Possibly that second Lordship has not added.
just in that part, make a correction.
2 FRs.
My esteemed sisters rightly pointed out, under 172, the accused will not, the other side will not be able to look into the case diary except the government counsel. So my esteemed sister is right. We'll have to find out a way. We can, on the next day, we can appoint an amicus curiae who may read the case diary and assist us. Because we won't have time to look into the case diary and then
Lots,
for ourselves and to see. Somebody will have to assist us.
lots of. Where are the other persons? Sunny?
Seat after that. There's a special bench on 24th. If we sit on that day, we'll take it up.
Lot. Lot of.
What did you say that? The respondent seven shall ensure that the case diary is, case diary and all other relevant materials are produced before, produced before the placed before the the learned senior government advocate by 23 positively on or before 23/7/2024. Next by list on 24/7/2024.
Mal.
We'll see on that day. Please remind us for the inspection of records.
Lot. And Malad.
Also, just a moment. The issues of notice on the other respondents are deferred for the time being. Okay,
Malad did
list on.
only that 10/7/25 is a second order, Malad.
Oh, sure. I
It
wanted
is
to-
giving
second.
effect of the second FR.
Uh,
That logic may be.
Oh, okay. Here you say that the initially on investigation and FR was submitted in connection with what is that 132?
Titapur PS
Titapur PS case number 132 of
23.
2025,
3.
23. Full stop. Upon protest petition being filed, the reinvestigation was ordered, which was done by that Dole, huh?
Miraj Dole.
Viras Dole. Just add this.
Second Miraji Dole is the first investigation. Second is SP Sipsakar.
SP,
Sipsakar.
Subhrajyoti
Bora.
Bora.
Subrajyoti Bora, paragraph 12 of our author.
okay. Thereafter, the investigation are handed over to,
Sri Subrajyoti Bora,
please
IPS.
give the spelling.
SUBHRAJYOTI.
In the magistrate's order, after the first protest petition was filed, the Honorable Magistrate ordered for a investigation by an IO who has to be a senior rank officer to a SP. But what the state police did was, the state police handed over the investigation to a SP rank officer.
Okay. Please remind
was
us.
a violation
This will be
of,
very important. Please remind us on the next date. This will be very important when we next time look at the matter, please tell us.
Independent investigation was directed, it was given to
No,
the
it's okay.
SPC.
It was written.
We'll-
The investigation was done by Subrajyoti
Subhrajyoti Bora IPS,
Bora IPS,
Superintendent of Police, Sibsagar.
Superintendent of Police Sibsagar, who also submitted an FIR after investigation.
Lodging.
Just make this correction, huh? Okay.
All around.
Item 4.
May it please, Your Lordship.
Yes.
My lord, this retaping has been preferred against an order passed in an IA whereby the learned single judge Milord refused to vacate the interim order, and while doing so, Milord, no reason has been assigned. Now, facts are like this, Milord.
Where is that order?
Yes. Order of the learned single judge Milord is at page number 76.
Okay.
And lordships will kindly come to page 82.
You're saying that while vacating, no reasons was assigned?
Yes, page 82, Milord. This court has para 10. This court has considered the submission made by the learned counsel for the parties. This court has noticed that the sole opposite party has filed WPC number so and so, challenging the order dated 22/10/24 by which opposite party has been allowed to complete the contractual obligation of the contract up to 34/25. The said writ petition is still pending for disposal. During pendency of the WPC number of 6124 of 24, the applicants issued an IT dated 1/2/25 seeking bids for providing catering and other services in BGR Guwahati Guest House and Office Complex at Jayanagar 6 Mile Guwahati for a period of 2 years. This court, while passing the interim order, has taken into consideration all preceding events prior to filing of the WPC number so and so. Without expressing any opinion on merits of the case, this court is of the considered opinion that when the sole opposite party has filed WPC number 612442 of 24 challenging the order dated 22/10/24, by which sole opposite party was allowed to complete the contractual obligation up to 34/25, which is still pending for disposal, and therefore in the event of an interim order dated 12/2/25 is vacated and applicants are permitted to finalize the NIT dated 1/2/25, the very purpose of filing WPC would be defeated. In view of the matter, this court is not inclined to vacate the interim order dated so and so. My lord, what had happened, my lord? Now kindly mark this date 34/25. Now, his contractual obligation was up to 34/25. Thereafter, a fresh NIT has been issued, my lord, on 1st of February 25, in which the writ petitioner opposite party has not even participated. Now, that tender process has been stayed. Now, I'll just give a factual background, my lord. It's very... My lord, on 29/3/23, work order was issued to the writ petitioner respondent for operating, my lord, the guest house of the Indian Oil Corporation, that is Bongaigaon Refinery at 6 Mile Guwahati. He operated the contract for some time. Thereafter, my lord, he stopped operating. Therefore, we terminated the contract. The termination order is 6/11/23. Now, this termination order was challenged in WPC 785 of 2015, my lord. If your lordships, where the termination order was interfered with and then direction was issued, which your lordships will get at page number 51.
Please give the termination order again, date.
Termination order is 6/11/23. I'm not troubling your lordships with the reasons of the termination. That may not be necessary at this stage. Now, this order was interfered with and the operative portion of the judgment is at page 51.
Five one.
Yes, my lord. A coordinate bench of this, a single bench of this honorable court, my lord, interfered with the order. In para 17
This
and
is order
18,
dated.
judgment is dated, my lord, 6/9/24. Page 51, para 17 and 18. In view of the aforesaid facts and circumstances, this court is of the opinion that a case for interference is made out. Accordingly, the termination order dated 6/11/23 is interfered with. Consequently, respondent is directed to allow the petitioner to complete the contractual obligation in terms of the work order dated 29/3/23. It is also made clear that respondent refinery cannot restrain the petitioner from engaging its own man for discharge of duties. Since the contract was for 2 years and because of the issue involved, the petitioner could not discharge the same, the petitioner would have liberty to file application for allowing to discharge the functions for full term, and in case such application is made, same would be considered by the respondent refinery in accordance with law by passing a speaking order. My lord, up to 34/25, that in terms of the judgment that he would be allowed to operate, there is no dispute. Regarding full term, my lord, this learned single judge gave him an option that you may apply and authority will consider. Now, authority passed an order at next page, my lord, on 22nd of October 24,
What was the end period? 31?
34/25.
34/25.
Yes. Now,
Yes.
pursuant to the judgment, my lord, at page 52 on 22nd of October 24, this order was passed. Now, please come to page 53. My lord, sorry, I'll have your lordship's kind attention to page 52, last 3 sentences towards the bottom. Whereas GEM contract dated 29/3/23 for providing catering and other services in BGR Guwahati Guest House, an office complex at Joyanagar Road 6 Mile, dated so and so, was awarded to SH Enterprise as per terms and conditions of the contract. The duration of contract is for 2 years from the date of handing over of the site. Site was handed over on, my lord, 1st of May 2023. Whereas the above work order commenced on 1/5/23 as per acceptance of GM contract, following kick-off meeting held on 25/4/23, SH Enterprise have agreed to start the job on 1/5/23 and started execution of job from 1/5/23. But SH Enterprise have failed to carry out the job of running the services of the guest house at 6 Mile, following which a show cause notice has been served to Messrs. SH Enterprise for leaving the work site and failure to carry out the execution of the contract, and subsequently termination notice of contract was issued to SH Enterprise on 6/11/23. Being aggrieved by the aforesaid termination order, SH Enterprise filed a writ petition before the Honorable High Court. Whereas the Honorable Guwahati High Court, by judgment and order dated 6/9/24, set aside the termination order dated 6/11/23 and allowed SH Enterprise to execute the job as per the work order dated 29/3/23 to complete the contractual liabilities of the contract. Now, therefore, in view of the above, you are hereby directed to complete the contractual obligation of the contract for the remaining period of the contract up to 34/25, subject to outcome of the writ appeal filed by so and so, so and so, so and so. My lord, this writ appeal was filed by the workers, employees, laborers, my lord, contract laborers. You were also advised to kindly confirm acceptance of the above contract as well as modalities for taking over the site for execution of the contract, completed required contractual formalities. Further, it is to mention that honorable court or court order will not create any equity in favor of either of the party, nor the Guwahati High Court, so and so, so and so. So, my lord, pursuant to this order, we have allowed him to operate up to 3425, and the other portion was not given expressly. Then, my lord, now, therefore, he did not, pursuant to this, he did not started the operation, my lord. Instead, he challenged this order in another writ petition, which is now pending before the learned single judge. Now, my lord, law on this point is,
Just a moment.
yes,
You required them to accept the remaining part of the contract. They did not
Exactly.
accept.
no, they did not. Instead, they filed a writ petition challenging this order, my lord, which is now pending before the learned single judge. Now, my lord, the question of law in the given facts which arises in my humble submission is, my lord, once the period of contract has come to an end, does it survive for performance or it survives for resolution of the disputes which arose when the contract was alive? My lord, that's the law laid down by the Supreme Court, my lord, in Damodar Valley Corporation's case. Now, he having not participated in the tender process, he has no right. If he succeeds in the writ petition, whereas challenge, he can sue for damage. But there is no right for performance, my lord. This is what the learned single judge failed to appreciate. Now, please come to paragraph 11 at page 1. It starts at, para starts at 147, my lord. The citation is 1974, 1 SCC 141. My lord, if your lordships would kindly come to page number 148, line about 6 from the top, para 6, where the Supreme Court has laid down this proposition.
Mr. Chaudhary, paragraph, please give it again.
Para 11, my lord. It starts at page number 147. There were 6 different situations which was being considered or visualized by the Honorable Supreme Court. We are concerned with the 6th proposition, my lord. At page 148, line about 6 from the top. Between the two falls, the sentence starting with and within bracket 6 on the right hand side top. Between the two falls, many categories. Has a lots of got it, please. Between the two falls, many categories of disputes in connection with a contract, such as the question of repudiation, frustration, breach, etc. In those cases, it is the performance of the contract that has come to an end. But contract is still in existence for certain purposes in respect of the disputes arising out of it or in connection with. As the contract subsists for certain purposes, the arbitration clause operates in respect of these purposes. In those cases, we have, as stated earlier, it is the performance of the contract that has come to an end, but the contract is still in existence for certain purposes in respect of disputes arising under it or in connection with. We think that as the contract subsists for certain purposes, arbitration clause operates in respect of these areas. So, in my humble understanding, my lord, subject to what your lordships may say, once the period of contract has come to an end, the performance is something which is, my lord, abhorrent. Now, what subsists? So, tomorrow, my lord, if he invokes arbitration, then there will be a dispute that has to be adjudicated. Now, after the order of the learned single judge, when we allowed him to operate until 3425, there is an order which is under challenge. I will not make any comment on that. If he succeeds and represents, perhaps he can maintain a civil suit claiming damage. But my lord, where is the right to continue? That is what he is asking for before this honorable court. And we also said in the tender process, pursuant to 1-25, he has not even participated in the tender process, and that tender process has been stayed. And we filed that IA for vacating that order. My lord, it's a the service of catering is very important for our organization. Now it is in limbo. Now, original dispute is, my lord, there are certain contractual leverage. Now, there was not much clarity in the contract, but management insisted that you must continue with them. But he said, no, I'll engage my own men. That is the dispute. Now, that's why the workmen also filed an appeal. Meanwhile, the contract period expired. Division bench closed the writ appeal by keeping the legal issues open. So, in that view of the matter, my lord, the interim order which was passed in this case, that should be vacated. That order should be stayed, and we should be allowed to go ahead with the tender. And depending upon the outcome of the writ petition, in which he has assailed the, my lord, that order by which he has been allowed to operate up to 34/25, the law will take its own course. So, my lord, therefore, this
That was a condition of the initial contract, that you'll have to take the unionized labor.
no, my lord, there is no clarity in that. There is some gray areas that, let me be very clear about it. We have, of course, there are materials to suggest by inference that they have to, because there are a lot many settlements between the management and the workmen, where, my lord, this aspect also featured. But there is no clarity on it.
Okay.
Now, my lord, my simple case is, now in the fresh NIT which has been issued, now he has not participated, yet he has stayed. Is it permissible? That is a stay order whereby, my lord, we have been stopped from formalizing the contract. But that's why, my lord, I feel, my lord, I submit the learned single judge as erred in law in not appreciating the legal position that once the period of contract has expired, there is no right of performance. What remains is, if there is any dispute, that is to be considered. That is my humble submission. We should be allowed to, complete the contractual terms, my lord.
Yes.
Maybe. My lord, it is not, the matter is not as simple as my learned friend has submitted. My lord, the trouble started during the period of the contract, my lord. Not even during the period of the contract, during the beginning of the contract.
That is a good art, because if for simple people like us, a simple argument is better. Had
My
we
lord,
been-
but not
had
based
we
on
been
fact.
a complicated, both of us complicated, then
No.
maybe a complicated argument would have come from Mr. Chaudhary.
My lord, but it has to be based on facts. It is not based on facts. That is where the problem lies. No, my lord, we were awarded a contract to run the BGR guest house at Guwahati for a total value of 2 crore 80 lakhs approximately, my lord. Even before we started the contract, we were driven away from the work site, saying that you cannot engage your own contractual laborers. You have to engage our contractual laborers provided by us, which has violated the terms of the agreement. That is clause, to be more specific, clause 2.2.1, my lord, wherein it is very specifically stated that, my lord, the contractor shall provide all workforce for the performance of the contract. Then they gave us a notice of termination, for which he had come to before this honorable court. Finally, in October, they terminated our contract. We again came by another writ petition before my lords. But finally, on 6/9/2024, the learned single judge passed a judgment and order. My learned friend has already taken, my lord, to the operative part of the order at page 51, my lords. Yes. why am I repeating, my lord, this operative order, operative part at para 17 at page 51, my lord. In view of the aforesaid facts and circumstances, this court is of the opinion that a case for interference is made out. Accordingly, the termination order dated 6/11/2023 is interfered with. Consequently, the respondent refinery is directed to allow the petitioner to complete the contractual liabilities in terms of the work order dated 29/3/2023. It is also made clear that the respondent refinery cannot restrain the petitioner from engaging its own men for discharge of the duties. Now, this observation has settled the issue that we could not perform the contract because of them, because they restrained our men from performing the contract. Most arbitrarily, most illegally, they have thrown us out of the work site. And that has been reflected in this judgment and order at para 17. That they cannot, it is also made clear that the respondent refinery cannot restrain the petitioner from engaging its own men for discharge of the duties. And it has upheld the clause 2.2.1, which says that I have to engage my own workers in the workplace. Subsequently, at para 18, since the contract was for 2 years, and because of the issue involved, issue is that restraining my men from performing the contract, the petitioner could not discharge the same. The petitioner would have the liberty to file application for allowing to discharge the functions for full term. In case such application is made, the same would be considered by the respondent refinery in accordance with law and by passing of a speaking order. Both these petitions are accordingly stand allowed. Now, my lord, this judgment and order has not been appealed against in any, my lord, appellate forum. Without appealing, they have passed this order at page 52, my lord. 52 is the speaking order as directed in para 18 of the judgment and order. Here in the speaking order, there's no speaking order actually, my lord. It's not based on any law. It is without any application of mine. This court is of the opinion that a case of interference is made out according to the termination. They mentioned the judgment, the part of the judgment. Now, what they say, whereas at page 28, my lord, whereas the above work order commenced on 1/5/2023 as per acceptance of GEM contract following the kickoff meeting held on 25/4/2023, MS-HS Enterprise has agreed to start the job on 1/5/2023 and started execution of job from 1/5/2023. Now they say that we have left the work site, we did not complete the work. Now here they say that we have agreed to start the job and started execution of the job in 1/5/2023. But SS Enterprise have failed to carry out the job of running the services of Guest House 6 Mile. The same issues of the writ petition of which is decided by the learned single judge, they've again brought it here. Those issues have been settled. We have not appealed against that order. So you have complied with the order. So to go through a middle way to subvert their judgment, they have allowed us only 5 months of extra work. Now, I am a small contractor. I'm not a big contractor. I have taken loans from banks, financial institutions. I have invested money in the work. Along with workmen, I paid them. If a 2-year contract for 2 crore 80 lakh is cut down to 5 months, where will I make a profit? Where will I work? Where will my money come from? How will they manage the calculations, my lord? Agreed by this order, we filed the writ petition 6142, assailing that speaking order of the respondents. While the learned single judge has issued notices on this writ petition and asked them to reply, but they have not replied. They have been taking adjournments time and again and not doing the hearing. Again, to subvert this earlier judgment, they issue a tender notice of a fresh tender. Now, rightly or wrongly, the single judge has restored the contract. The single judge has asked us to perform the rest of the contract and also asked us to apply to the respondents to grant us 2 full years term because we could not perform our contract because they did not let us perform our contract. It would be wrong to suggest that no, you have got, you can take compensation later on. We will go ahead with the contract. Now, to subvert and overreach this single judge's order, they said that they know we are not going to participate in the contract, in the fresh tender, because there's already a tender contract subsisting. Has that earlier contract been cancelled by them? No, my lord. There's no cancellation order of the contract. The contract is still subsisting, and when the contract is subsisting, when the issues are before this honorable court, before the learned single judge, they issue a tender. Before the submission of bids, my lord, we filed another writ petition, that is writ petition 738. Before the
I'm just reminded of what happens to at my home. By the time I wind up the office work, which I have to do, that is correction of orders and all, it's about 7:30 daily. So it takes me 10 minutes time to go home. And by the time I go home, and if some food is not ready, I have a bad habit of taking a spoon and then hitting it on the plate, so that everybody in the home knows that they must give me something. I'm famished. This happens regularly. I'm just asking you, if this happens to me in a guest house, if there are guests, what will happen to them? If there's nobody working, nobody serving food to them, what will happen? I don't know, what I'm doing is childish. I take the spoon and then start hitting the plate. It's my way of expressing my hunger. But what would happen to these guests who are in the guest house with no cook?
my lord, as per the direction of the single judge in the earlier writ petition, they were allowed to make temporary arrangement, and the canteen is running through temporary contractors. And my lord, so if that is the case, my lord, they should immediately let us get into the workplace and start our contractual liability.
They gave you an offer, you did not take it.
No, my lord, we did, my lord. What they did, because at para 18, the learned single judge has allowed us to file an application, because that is very important, my lord.
No, unless you start the work, there is no credibility that you will continue.
No, I
for the
will,
rest of the.
because my lord, if my lord again comes to the order of the learned single judge, this happened not because due to our fault. We did not shirk our responsibility of completing a contractual liability. This issue arose because of certain issues. My lord, I'm not an affidavit now, but I can just make a statement across the bar. These contractual laborers, this is a syndicate kind of a thing. These poor contractual laborers, where sometime some things must have been taken from them, assuring them of work, permanent jobs in IOC, which the officers before and now could not do that. They are also, these contractual laborers are also employed as domestic helpers in the officers' homes. So since they don't.
For that, there is a judgment. SBI, what do you call, Canteen Employees Association.
My lord.
So therefore, we know what happens.
My lord. So what has happened now? We said that enforce clause 2.2.1, wherein it is explicitly, it is clear in the contract that we have to engage our own workers in the work site. That is 27 numbers of skilled workers, not domestic helps, skilled workers, my lord. 27 numbers. I have to take the responsibility. If they do anything wrong, I shall be penalized. If there's any misdemeanor of one of the workers, I'll be penalized by the respondent authorities. So this skilled worker, they said most of them don't even know to operate the computer. One of the requirements is that the manager has to know to operate the computer and make bills. How can a domestic help come and work as a manager? How can we employ them, my lord? Even in any view of the matter, my lord, the contract is very clear, 2.2.1. When we went to the work site, they did not let us enter the work site, saying that 27 skilled workers will not be here, only our workers will be here. which we disagreed, because this is a professional work. This is not only providing canteen services, my lord. Guest house means we have to look after the bedrooms, linen, laundry, housekeeping, everything, my lord. Everything is covered. It's not only giving a plate of food. This is a highly professional work, my lord. And we have to give breakfast, lunch, dinner, continental, European food, Indian food. We have to be expert in everything. How can we engage 27 numbers of domestic help workers of the refinery? Why should we? Whose liability would that be? It will be my liability. Nevertheless, my lord, this in the judgment passed on 6/9/2023.
Take a short break and come back. Yes. You're relying on any case citations also?
My lord, only one, my lord. But before that, my lord,
Hmm.
my lord may kindly come to the judgment and order dated 6/9/2024, and of a relevant portion I may read, my lord, at page 46, my lord, and start. Para 8.
Yes.
If I may read it, my lord, at para 8, page 46.
Yes, yes.
On the aspect of the maintainability of the writ petition, the learned senior counsel for the petitioner has placed reliance upon the cases of MP Power Management Company Limited, Jabalpur versus Sky Power Southeast Solar India Private Limited and others reported in 2023, 2 SCC 703. And ABL Industrial Limited and another versus Export Credit Guarantee Corporation of India and others reported in 2004, 3 SCC at 553. In the subsequent decision of MP Power, the Honorable Supreme Court has relied upon a host of previous decisions, including the case of ABL Industries, Supra. It is submitted that the respondent authorities, being an instrumentality of the state, is bound by Article 14 of the Constitution of India to act fairly, justly, and reasonably. He accordingly submits that the impugned order of termination of the contract be set aside. Para 9, per contra, Mr. King Chaudhary, learned senior counsel for the respondent refinery, has submitted that on 1/5/2023, the petitioner has started operating the canteen, which was done for a month, and on 8/6/2023, a new list of workers was given by the petitioner. Regarding the submission that the petitioner can engage his own men, he has submitted that if there was a change in the existing workers, the same will lead an industrial unrest, which would not be in the interest of justice. By referring to the affidavit in reply filed on so and so, the learned senior counsel has submitted that there is a binding settlement between refinery authorities and the contract laborers, as per which such laborers are given certain safeguards. He also emphasized that there is no clause in the contract agreement with the petitioner which would enable the contractor to have his own men. He has submitted that the settlement between the Workers' Coordination Committee and the refinery, which contains several clauses, which are mainly to ensure safeguarding the interests of the contract laborers. He submits that in absence of an enabling clause, which gives the right to the contractor to engage his own men, the decision to have the earlier set of workers to continue cannot be termed as arbitrary and unreasonable, and therefore he submits that there is no merit in the writ petition which is liable to be dismissed. As regards the nature of the job, it is submitted that the same is of essential nature, involving catering and other services, and in the order dated 4/1/2024 passed in IA number so and so, the refinery authorities were given the liberty to make alternative arrangements. Now, at para 12, page 48, the list involves the scope of the work as a caterer in the guest house of a refinery at Guwahati. The work order was issued on 29/3/2023, which has been carefully perused. This court has also examined the other materials which relate to the relationship between the refinery and the petitioner. Clause 2.2 of the agreement deals with the contractor's scope, as per which the contractor was to engage adequate numbers of workers. The aforesaid scope of work cannot be constituted to put a fetter on the contractor to engage the previous workers of the previous contractor. The transaction involved is of commercial nature, wherein the bids are offered after making certain calculations, which would include the nature or scope of engaging workers in a strategic manner. While exploitation of any nature of the workers will not be permitted in any case, and the contractor would be bound by the provisions of law to ensure that they are given their due, the same cannot be stressed to the extent of curtailing his rights so far as the engagements of a particular set of workers are concerned. This court has carefully looked and relooked at the settlement which is in existence between workers' committee and the refinery, when the various clauses ensure that the rights and interests of the contract laborers are secured by payment on a prescribed rates, medical allowance, other benefits. The same does not have any clause which would ensure their continuity when there is a change of the contractor. In absence of such clause, this court finds it absolutely difficult to impose upon a third party of a condition which would have a direct impact on the manner of discharge of his functions in the terms of the contract. This court is of the opinion that even assuming such a clause existed in the settlement, the contract with the petitioner is of a subsequent date, and unless the contract contains a clause of restriction and specifying a particular manner for engaging workers in terms of settlement, such a condition cannot be imposed upon the petitioner. At page 50, para 16, my lords. As regards the question of maintainability is concerned, no serious issues were raised on behalf of the respondents. In any case, the Honorable Supreme Court in the case of MP Power has made the position clear. By referring to the catena of earlier judgments, including the case of ABL International, the following has been laid down. ABL marks a milestone, as it were, in a matter of superior court interfering in contractual matters where the state is a player even after the contract is entered into. A petition was filed under 226, wherein the respondent, which was incorporated under the Companies Act, repudiated an insurance claim made by the appellant writ petitioner. This court undertook an elaborate discussion of the earlier case law. If we find that this court dealt with several obstacles which were sought to be posed by the respondent, they included disputed questions of fact being involved, availability of alternate remedy, and a case involving entertaining a money claim. This court went on to hold as follows. From the above discussions of ours, the following legal principles emerge as to the maintainability of a writ petition. A. In an appropriate case, a writ petition as against the state or an instrumentality of a state arising out of a contractual obligation is maintainable. B. Merely because of some disputed questions of fact arise for consideration, same cannot be a ground to refuse to entertain a writ petition in all cases as a matter of rule. C. A writ petition involving a consequential relief of monetary claim is also maintainable. And then it passes the effective order at para 17 and 18. Now, my lord, this ABL International is a milestone case. It is 2004, my lord. The citation is 2004, 3 SCC at 553. 2004, 3 SCC at 553.
Yes.
Now, my lord, this judgment of 6/9/2023, where both the writ petitions were allowed, this new tender in 738, this is before against which we have come before by filing writ petition 738, my lord. This tender seeks to make this judgment redundant and inoperative. Can it do so, my lord? It is before your lordship, my lord. Can this fresh tender override this judgment, close down this judgment? Can it be allowed? Can a tender? Yes, ordinarily, my lord, in ordinary circumstances, I have to participate in a tender to challenge the tender. That is there. That's undisputable. But my case is that my contract is subsisting because the court has restored this contract. There's no letter of the respondent saying that because you have refused to accept our fresh proposal, we are hereby terminating your contract. Have they come to they should have come to the court. Before issuing the tender notice, they should have come to the court and taken leave of the court. We have neither challenged this judgment, not appealed against, we have not appealed against the judgment. So just to circumvent and override this judgment and make this judgment redundant, you have, fully knowing that we will not participate in a tender, we have floated a tender. And we have defeated this order dated 6/9/2023. Can that be allowed? How can a tender matter, how can a fresh tender override the judgment of a standing judgment of this honorable court? Now, my lord, kindly come to the interim order passed in 738, my lord. First of all, what did the interim order say? This is page 73, my lord. This order, interim order dated 12/2/2025.
It is, in connection with this appeal,
My lord.
this W 152, can we have the copy of writ petition where, what is the prayer of the writ petition, where it is available?
1 second, Miller. That is this, huh? The prayer was, my lord, that they should be allowed to operate, they should be allowed to complete the period of the contract.
That is in 6142.
Hmm?
6-1.
Is it available here? Which page?
I'm sorry.
You have a copy with you?
At present, today, I don't have, Miller.
Okay, you have a copy of the writ petition?
Repeat, yes, my lord. 6142 or 78, my lord.
No, I don't know. This appeal 152 arises out of which writ
78.
petition? I want that writ petition.
78, my lord.
Just a moment.
78.
After your submissions are over, please give it to us. We'll return it back.
My lord, my lord. So, my lord, at page 73, my lord, this is our interim order in 738, WPC 738, 12/2/2025. Heard so and so. This writ petition has been filed by the petitioner, who is the contractor who provides catering and housekeeping
You
services.
omit that part, come to the relevant part,
My lord,
because we have to rise early.
my lord. At page 74,
Yes.
at this juncture, the petitioner has approached this court by filing the present writ proceedings, putting into challenge the NIT issued by the respondent authorities, being NIT dated 1/2/2025, seeking bids for services of the same item category by the respondents. The contract is also for 2 years. The learned counsel for the petitioner submits that where there is a specific direction by the court interfering with the termination order issued by the respondents and directing the respondents to permit the petitioners to operate all the full period of the contract awarded, and where that there no order is being complied with, the petitioner has also approached this court seeking specific direction from this court, being WPC 6142 of 2024, and the said writ petition is pending. The present action of the respondents issuing the NIT is arbitrary and is an attempt to overreach the orders passed by this court. It is submitted that if the tender process is allowed to proceed with, the petitioner, in spite of having the orders from this court, will not be permitted to operate this tender for the full 2 years. Being aggrieved, the present writ petition has been filed. The learned counsel for the petitioner has also submitted there is no standing counsel for the respondents. Let the notice be so and so. In the interim, the tender process initiated process initiated by NIT dated 1/2/2025 shall not be finalized with the leave of this court till the next date is fixed. Now, my lord, in the IA, where the learned single judge has refused to vacate the interim order, my lord, this is at page page 82 at para 11, my lord. This is the order in the stay vacating application. The court has noticed that the sole opposite party has filed WPC 6142/2024 challenging the order dated 22/10/2024 by which the opposite party has been allowed to complete the contractual obligation of the contract up to 3/34/2025. The said writ petition is still pending for disposal. During the pendency of 6142, the applicants issued to NIT dated 1/2/2005 seeking bids for providing catering and other services in BGR Guest House, Guwahati, office complex at Joynagar Road, 6 Mile, Guwahati for a period of 2 years. This court, while passing the interim order dated 12/2/2025, has taken into consideration all the preceding events prior to filing of WPC 78/2025. Without expressing any opinion on the merit of the case, this court is of the considered opinion that when the sole opposite party has filed WPC 6142 challenging the order dated 22/10/2024 by which the sole opposite party was allowed to complete the contractual obligation up to 34/2025, which is still pending for disposal, and therefore in the event the interim order dated 12/2/2025 is vacated and the applicants are permitted to finalize the NIT dated 1/2/2025, the very purpose of filing the WPC 6142 would be defeated. In view of the matter, this court is not inclined to vacate the interim order dated 12/2/2025 at this stage. Now, my lord, if my right before the single judge is taken away, my lord, 6142 is now any judgment against me in the appellate court would render 78 as well as 6142, my lord, inoperative without any legal discussion, my lord. Because if any order is passed here, it would affect the outcome of 6142 as well as 78. Now, what I would like to implore my lordships to consider is whether this fresh tender can violate a High Court's order standing out of this honorable court. It is an attempt to make this judgment order redundant and inoperative. Just because they have not appealed against this order, they are not before the appellate court. So they want to go this way and hold their ears, and the end objective is to defeat me. Now, since the day one, they have been telling the court they have to go to the civil court, they have to go to the civil court. But ABL has laid down the law as to where can a writ court interfere. Now, I can file for damages also before the writ court, subsequent damages also before the writ court, because the finding of the learned single judge is that the actions of the respondents, of the appellant, has been arbitrary, malafide, unfair, and unjust. They have violated the terms.
Perhaps there is a shift in the appreciation of tender matters in the recent judgments, starting from NG projects. The earlier view,
Difficulties are there,
the earlier view is perhaps
diluted.
will not say diluted, but it's the
Paraphrase.
because it's not even paraphrase. It's a 3-judge bench now. They have, in their wisdom, they have taken a different view.
My lord, ordinarily, my lord, it is my lord, akin to taking the courts for a ride. They've been taking the courts for a ride, my lord, all the time. By diverting to the issues doing this and that. They have not come to the main petition, they have not complied the order, but they are issuing tender notices, they're doing this just to subvert this, the ends of justice which has been rightfully given.
Pass orders in course of the day.
Yes. Well, only
Uh,
one thing.
Please,
Just 2
please give
minutes
that
time.
copy of the writ petition. We'll
Yes.
give it to you. Court Martial will give it to you tomorrow.
Yes. Lord, my learned friend has made a submission that against the order of the learned single judge, no appeal has been preferred. That is not correct. Appeal was preferred by those contract laborers, my lord. This is the order passed.
Not the
Now-
refinery, not the refinery, not
Of
the
course
appellate.
not. I have never said that we have filed appeal. Please come to this order, my lord. When this writ petition was moved, why copy was not served upon us? When the interim order was obtained.
No,
Anyway, my lord,
there's no-
kindly come to the
There's no
last page.
standing council of the refinery.
There
my
is,
lord.
there is.
There's no IOC.
There is. Go to registry, check up with the registry.
We
There
have
is.
checked up with the registry. There's
There
no-
is.
There's no.
Being
there's no
aggrieved
standing
with the order passed by the learned single judge, the employees of the erstwhile contractor have challenged the said order by way of this writ appeal. It is informed that the contract period for which Messrs. Assets Enterprise was awarded the contract is already over. And in the meantime, IOCL has also floated a new tender, which is subjected to challenge by contractor in so and so, and the same is pending consideration. In view of the above facts and circumstances, we are of the view that this writ appeal can be disposed of while keeping it open for the appellants or any other party to press the question of law raised in the appeal in appropriate proceeding. The question of law, whether the contractor is bound to accept the Millard contractual contract laborers, that question is kept open by division bench. And why the division bench closed the matter? Because the period of contract has come to an end. So that is the understanding of law, my lord. Once the period of contract has come to an end, the performance is forbidden.
My
What
lord-
survives is if there is any dispute which arose when the contract was in existence, for that arbitration clause would arrive, will subsist. My lord, all that my learned friend is submitting, he is absolutely correct. There was something arbitrariness in the decision-making process. That's why learned single judge interfered. Now the question is, after the end of the contractual period, whether we are obliged to give him the entire whole period or not. That is a question which is still open. This very argument can be made there. And all that I am saying is, my
I
lord,
agree.
all
It
that
can
I
be-
am
it
saying,
can be-
all that I am
Not to
saying is, once the period of contract has come to an end, perhaps you cannot claim right to perform. Well, at end of the day, why do you file a writ petition? We file a writ petition to enforce our legal right. Now, what is the legal right which my learned friend's client is purporting to perform? Is to perform the contract. The issue is whether that is a right which can be accepted in law. In my humble submission, because of the judgment in Millard, this Damodar Valley Corporation, Millard, which is a well settled proposition, he may not have. Yes, if he succeeds, then he can certainly sue for damages. End of the day, Millard, now as the Lordship just rightly pointed out, what is the view taken in NJ Exports? The sentence is, even if there are arbitrariness and illegalities, writ court should not interfere. Parties should be relegated to civil court for damages. So that is the underlying Millard principle. That's my only submission. And all these points he can always hesitate. There is no problem. But question is, there is no indefeasible right that after the period of contract has come to an end, he still can insist that no, I should be given the full term. Then, my lord, what is the difference between civil court and 226 jurisdiction? Then it will cease to become a part of judicial review. It would become an appellate jurisdiction. Let us go to the fundamentals.
My lord, in the appellate, my lord,
Deeply obliged.
my lord, in the appeal, my lord, I had informed the court, the appellate court, the learned division bench, that the writ petition 78 has been filed because a fresh tender has been issued. So the learned division bench said that the honorable division bench said, okay, then you agitate these matters before the single judge. Now, our prayers are very specific. If any order is passed here, my lord, what is left to argue there before the single judge? 78 and 6142 is gone. There are no issues to be discussed there.
Okay. Deeply obliged.
Just write the names, both of your names to the court master. Instructing possible,
Applies.
We have to rise for the single bench. There are two single bench. We have to rise for that.
Item 5 months just condemnation was a 55 days matter. I think other side may not have objection. Condemnation petition.
Which item?
Item 5. Mr. Shishi Datta appears for the 4 minor, response number 4, and government is there.
Item 5.
$55 days matter as per the registry's report in filing the ATP. Promotion case matter from LDA to UDA to superintendent. In this shape is
Other side is there.
My lord, I am for the private respond number 4 minute.
and government is there.
Are you objecting to the delay?
My lord, in fact, my lord, such a delay, I don't, but then your lordship will find what is the acceptability of explanation. Whether it is there at all, I leave up to your lordship, my lord. There is no explanation at all.
But then filing of objection would be necessary.
My lord, if your lordship look at paragraph 11, that is the only explanation they have
Paragraph
given.
11.
Yes,
Yes.
at page 6.
That I also admit, brother. He's right.
So even
Uh,
accept this, the
11 and 12. अरे हाँ, वो लोग हमारे भाई का बेटा था, मैंने कुछ लिखा भी नहीं है। वही तो हम बोला। ये ग्राउंड कौन लो? नसीबपुर में। वहाँ केस बात हो रही है।
But looking at Mr. Sharma, this appears to be a good ground.
Certainly,
Mr.
he-
I don't know.
Well, Mr. Sharma has threatened me. You don't object to it. Otherwise, there will be problem.
No, that is between
we are sitting in the
that is between two senior counsel. We are not nothing to say.
my lord, we are sitting in the same room. I said, I will not offer a cup of tea.
No, that's okay. But you see, this ground appears to be right when Mr. Sharma is there.
Hello. The problem is what we know in our bar nowadays, unlike earlier days. The junior, they get the license the day they get the license, Manu, they become self-made seniors. That's what in one of the items your
No,
lordship
that we
was.
don't know, but we are now appreciating paragraph 11.
Yes,
Paragraph 11 says
yes,
that he was financially not in a fit position to
yes, LDA system.
to give legal fees.
You know, how much
So-
he used to exploit the client. your lordship.
Definitely, he is not in a position to give legal fees. You know the status of Mr. Sharma.
Doing it till today, Porobanna.
No, even we know that. Mr. Sharma,
Yes.
you are from that period
Yes,
where there's a story of a Ranjit Singh council who did the matters for free
yes,
and cost about 30,000 rupees was taken.
yes,
You remember those days?
yes. I remember.
You know the
I don't know. I was in the chamber.
you know the council also very well.
Yes.
Now he's no more.
My senior fees was 300 per repetition. And he would give me 100 rupees cost including our fees.
Now we know that it is in that period only matters were done for
He was
free.
a common man's lawyer, my lord, totally.
So we know when Mr. Sharma stands there, now there's a affidavit to support.
Yes. So let it become.
It's just objective of the cause.
थोड़ा सा ध्यान रखो
नेक्स्ट टाइम उन्होंने किसी से बार बार आकर मैं देखो ना कान संकारी दूंगा फंसा गई ध्यान अलग की जाती है
But Mr. Sharma,
इस
with, till you made that reply submission, everything was okay. But with your submission, then this would be a false affidavit. If you say that you are doing pro bono, and then he says he can't pay the fees, that means the statement is incorrect and we have to dismiss it then.
my lord no because they client might have paid
Is
this year because I'm
entrapment.
till today I'm on oath saying I haven't taken fishing away because I
No,
know
that's okay. You see, that's what we are saying. Pro bono means that only. If you're doing it pro bono, then he can't pay the fees. If something is inconsistent, we have to dismiss it then.
The statement is not correct.
till today they might have been given
They might have.
yes
अरे भी छोड़ो ये सब pro bono तो pro bono.
no juniors are to be paid
My lord, if it is pro bono, let it be pro bono also. The subsequent even he should not claim from his client.
no till today I'm telling
No,
you,
she
this
is
the work.
hearing her. She is hearing this in here. She appears to be smart enough.
No, my lord, in the morning she was scolded for some dipping the doubt. It is the
No,
end of
but
matter.
this can't be accepted. He's a essay in office. He says that he can't pay.
No, no, LD assistant, your lordship gets to run the family
This-
and aiding
this is not
aiding
sufficient.
parents.
This explanation is not sufficient. You file a better affidavit. This is not sufficient.
I will aid by additional affidavit, my lord. Yes.
Mr. R.P. Sharma and a senior counsel for the applicant, assisted by Ms.
Ranjita Datta.
Ms. R. Datta and counsel for the applicant submits, prays for some time to file a affidavit to explain the delay. Mr. S. Datta and a senior counsel for the respondent is, private respondent is
Respondent
Uh,
4.
respondent number 4, and Mr. P. Sharma and senior government advocate for respondent numbers 1, 2, and 3 are present.
2 and 3.
List
2 and 3.
when?
No, no, next week any day. By Monday we'll file.
Okay. List in the week commencing. You make it 25th, by then it will come. List on
Friday, my
25,
lord.
7/20/25, as in when 25, 7/20.
25th July, my lord.
Obliged.
Item number 11, that is in the, your lordship kindly fixes a date, my lord.
Let the court must be, we have single bench and we both have bail matters.
So we are, both the parties are, my lord, in attendance, my lord.
Court master,
29, my lord.
29 July.
29 of July.
the court master. Because we have.
29 of.
This is lordship. Made this lordship. Lordship, I beg to mention item number 2, lordship. Then adjourn for the day, lordship.
But an adjournment.
Yes, lordship. Item
Okay, we will gladly allow item 2 this time. We are making it next Friday.
Master, please.
Your lordship, I am for item number 1, your lordship. I seek pardon, your lordship. My senior is out of station, your lordship, and
We are listing it next Friday because this week there we are some disruption.
on 24th, your lordship.
No, 24th we already have few matters. It's Thursday.
On
It's a Thursday. We have a special bench on that day.
25th, your lordship.
20 is Friday.
Obliged.
There's an IA also, item 3.
1 and 2, I'm for 2. Obliged, your lordship.
Item 3.
Oh, this is for that modification of the conditions. Can we do it?
So I have taken state receipt, but it is yet to come also.
Pardon me?
I have talked to, I have communicated the order to the DCP client.
Okay,
But today, sorry, Mr. Today I could not follow up it was.
okay. Uh,
On Monday.
Mr.
next-
P.S. Lagal and APP prays for some more time to obtain instructions and to address the court. Full stop. Prayer is allowed. Matter stands adjourned today. List again on same 25th.
20.
Sorry, I did-
Wanting some time, we'll take it on 25th.
Lordship.
We'll just record his presence, just as the counsel of the petitioner is present.